Today, we're going to talk about net choice versus Paxton, a decision that was rendered by the Fifth Circuit Court of Appeals, the Federal Appeals Court in Texas. HB 20 is a Texas law that prohibits censorship based upon viewpoint. The law only applies to Texas residents, businesses that operate in Texas, or to anyone who, quote, shares or receives content on a social media platform in this state. The implication of the Fifth Circuit allowing the law to go into effect is that social media platforms no longer can censor speech that they find to be factually inaccurate, hate speech, or otherwise inappropriate. This has been an ongoing debate with the responsibility of platforms such as Facebook and Twitter coming into sharp focus. Should these platforms be allowed, or can they be allowed to prevent dangerous and unscientific speech, whether it's COVID or otherwise, from being on the platforms? And they all have taken responsibility to monitor and kick out users and otherwise restrict inaccurate and false information. If this stands, and in fact the Texas law goes into effect, as a practical matter, it would be very difficult to distinguish between businesses and individuals in Texas and anywhere else in the country, and would have a dramatic effect on the scope of allowable speech that currently has been banned. Stay tuned. This one has yet to be fully resolved, but without question, this decision, net choice versus Paxton, is the most significant challenge to social media platforms and their ability to censor or restrict inappropriate conduct. The last shot hasn't been fired in this battle, but it is a dramatic issue for everyone who uses social media and the social media companies themselves.